Charlie Rodman here. Today I want to talk about the Texas Administrative License Revocation Hearing, also called the ALR hearing. After a DWI arrest, if you blew over .08 or you refused to blow, they will suspend your license at the 40-day mark. Okay. Now, you have the right to request a hearing, either you or your attorney, but you have 15 days to do it. Okay, so if we request a hearing, or you do, what that does is it stops the suspension until the hearing happens. Now, this hearing can be reset a few times, but eventually it will happen. And what we do is we subpoena the officer or officers, depending if it's one or two people. And then if they show up, okay, it's difficult to win the case because they just explain to the judge why they stopped you or how you got their attention and why they thought you were intoxicated. And the burden of proof is very low. Okay, they just have to have reasonable suspicion to stop you, probable cause to arrest. But sometimes they don't show up. Okay, or occasionally we find some sort of evidence that can prove them wrong to the judge or shows the judge that they're not telling the truth. If that happens and we win, there's no license suspension through this DPS ALR process. But if we lose, okay, if they show up and they convince the judge that they had reasonable suspicion and probable cause to arrest, we can still get you an occupational license. Now, this requires some more things like SR22 insurance and a driving record. Anyway, there's some more steps to get that, but don't fear. If the ALR hearing, if we lose it, you'll be eligible almost certainly for an occupational license. All right, I sure hope that helps.